interest litigation is not just another regular litigation. He is involved in the defense of the public interest. And when you're involved in the defense of the public interest, you ought to give feedback to the persons who are interested in the litigation involved or in the prosecution involved. The OSP, therefore, occupies an office which not only is novel, but an office which was called into being by the public, so to speak. This is a matter that dominated political conversation for many years. I do not see and understand what the reason is that after having been established, the OSP should operate in private. Mind you, we have to bear this in mind, that the OSP is interested in public facilitation of his work. And so if an office is interested in the public facilitation of his work, that office invariably would have to engage that public. It is when the OSP speaks to the public that the public can be aware of the extent to which the OSP's work is progressing, what the difficulties and challenges are, and if the public thinks that there are any circumstances of complementing the OSP's work, the public may, so to speak, come out and engage. So I think the OSP is doing exactly what they're supposed to do. Justice is not, it shouldn't be a private business. You know, lawyers have traditionally said this, that look, let's keep some of these things quiet. The legal actors who are supposed to be quiet are known. Jurors and judges themselves, they speak through the bench. The people who are supposed to be quiet are there. Indeed, lawyers who are involved in particular cases. And I've heard lawyers on radio, and I think these days the media funds that, but it's quite unprofessional. And that I totally disagree with lawyers who do that. In other words, lawyers who are involved in cases in court, coming out of court and then literally continuing the litigation on radio or on TV, you know, and basically arguing against each other publicly. That I think is a bit unprofessional. But that is not what the OSP is doing. What the OSP is doing is to give public feedback on specific developments on cases involving matters before him. So I do not have any difficulty at all with the fact that he's giving updates or periodic updates of happenings in court.
Martin Amidu was accused of speaking too much and doing little. He's facing same accusation, but his is quite different at one level, that his commentary has tended to concern critique of decisions that have gone against him. The law that sets up the OSP says he should update us quarterly of the cases he's doing, the status and outcomes as well. The law says he should make a publication of detected acts that it is investigated, detected acts of corruption. The law says he should do public education, engage the media, and so on and so forth. That is not the same as taking decisions of the court and running an appeal.
Well, essentially, you've actually repeated what the statute says. Essentially, my understanding, and if I listen to him, my understanding of what he's trying to do is to get the public to come along with his challenges and difficulties. I can understand part of the concerns that some lawyers may be raising, and the concerns may perhaps be the seeming direct critique of particular responses of the courts and particular courts, the specific isolation of particular judges and particular courts in the circumstances of some of the challenges that he's facing. I think that the OSP is an evolving institution, and I think we need to understand that. I think Mr. Kisieja Ben has very little template, if any at all. Perhaps the one left by Mr. Martin Amidu. Beyond that, he doesn't have much of a template. And in this context, perhaps he doesn't even have a template at all. So we can understand some excesses which may be unintended, but fundamentally, if you look at what he is doing, he is trying to keep us abreast with happenings and events in the court. Perhaps some may say that he should begin going beyond the judges and the courts by actually keeping the public also abreast with specific developments of his investigations. Things that he may have found, things that he's having trouble finding, where he expects the public to come in, facilitations that he would expect the state to give him, for example. Some will argue that the office of the OSP is perhaps one of the most difficult offices anybody can occupy in public service in Ghana. And the reason for that is that it's an office that requires the level of facilitation which ordinarily doesn't obtain in our criminal justice system. The OSP is supposed to be a forensically led office, fundamentally speaking. And forensics, as we all know, forensic investigation in Ghana is still very much rudimentary. You are investigating offenses that are essentially consensual in character, offenses in which parties are collaborators and cooperative in terms of their behaviors. And so these kinds of offenses are quintessentially difficult to investigate. And the reason they are is because the persons involved, nobody's going to speak to you. I mean, if parties have collaborated and are happy to be involved in a corrupt act, nobody's going to be reporting them. And if you're speaking to them, they're not going to turn against each other. You will have to have independent sources of information to challenge and contradict people's positions and to get them to come clean. Typically in Ghana, the criminal investigation regime is still very much rudimentary. And as rudimentary as it is, the OSP is now going beyond the regular crimes, which are even less difficult to prosecute because they are normally not consensual. But corruption being fundamentally consensual, you will have to have an office that has that level of technical expertise and competence, and he's building things from the scratch. I think we need to give him a flag, and as I said, these may perhaps explain some of the things that some people may consider excesses in his feedback, but he doesn't have much of a template. In the circumstances, he's giving us feedback, and I think overall, the picture is the OSP is coming against headwinds. How does he overcome those headwinds? And in this context, I'm just going to say that the office faces three key difficulties. Now, the first difficulty is the one of mandate. The second difficulty is the difficulty of perception. And the third difficulty is a systemic difficulty. If you take the mandate difficulty, that's what I just spoke on briefly. That difficulty that says that you come to court, you prosecute cases, and you're able to establish things on the basis of convincing facts, and you're able to do so beyond all reasonable doubts. All the defense has to do is to raise one doubt. Now, we say these things, and it is nice, some will say it is sexy in our criminal jurisprudence, but the reality is it's very difficult when you're dealing with prosecutions because the persons involved, political exposed persons, and persons who are involved in corrupt acts, these are persons who have means. They are persons who can afford lawyers. So if they do pay for the best of legal services, and you are an OSP who has to convince the court beyond reasonable doubt, and then they have the best of lawyers, they are going to be able to raise one doubt or the other. That creates frustrations for an OSP who is trying to do his work. But beyond that, you have Section 38 of the law, which says the OSP has the authority and the power to actually embark on freezing orders. Now, the law is clear, and I think I understand that as part of his frustrations. If you listen to his tape that he played, you can tell that he's...
So do me this favor, you hold on with that. We are going to the substance of the examples that he raises that frustrates